Good evening, you're watching Left, Right and Centre. I'm Nidhi Razdan. This morning, the Vice President of India, the Chairman of the Rajya Sabha, outrightly rejected the impeachment motion filed by opposition MPs against the Chief Justice of India, Dipak Misra. Mr. Venkaiah Naidu said the charges against the Chief Justice were unsubstantiated and that this pillar of governance cannot be weakened. Senior lawyer and Congress leader Kapil Sibal later hit back, calling the Vice President's move illegal and unprecedented. He insists that the merits of the charges can only be decided by a special committee that has to be set up when a motion is tabled. At any rate, the opposition always knew it never had the numbers to impeach the Chief Justice. So why did they submit this motion in the first place? We'll be talking about that a little later on in the show. But first, let's take a look at what happened today.
The Vice President, after a series of meetings and consultations, ruled to reject the impeachment motion against the Chief Justice of India, Dipak Misra. Mr. Naidu ruled that their allegations against the Chief Justice indicated mere suspicion, a conjecture or an assumption, that it did not constitute proof without reasonable doubt, which is required to show proved misconduct under the Constitution. He consulted constitutional experts, former Secretary Generals of Parliament, eminent jurists, even the comments by former Attorney General and editors of prominent newspapers, and cited cogent relevant material from the Supreme Court orders. He wrote, "I have come to the conclusion that this motion does not deserve to be admitted and that there is virtually no concrete verifiable imputation." Mr. Naidu wrote, either the allegations are within judicial domain and concern internal judicial processes, or there are unsubstantiated surmises and conjectures. Mr. Naidu's ruling came within 72 hours of the MPs meeting him.
What was the tearing hurry? If he can't weigh the pros or cons for a prima facie case, how can he give a finding? This government is very keen that this must not be allowed to be inquired into. Maybe they have information that the CBI has information.
Authority of the Vice President to decide such motions is very, very clear. He has applied his mind, he has passed a detailed order.
By virtue of chair, application of mind is something which everybody who's in decision-making power has to exercise decision-making. It's not a post office.
Rahul Gandhi gave his tacit support to ensure that senior leaders like Ghulam Nabi Azad and Kapil Sibal backed the move. But not only has it divided the opposition, but within the Congress, with two of its former law ministers attacking the decision of the top party leaders.
Vice President of India, who is also the Chairman of the Rajya Sabha and entrusted by the Constitution to decide on such petitions, has now given a reasoned order. It is now for the individual members to study that order and decide if they want to take any further action.
I would imagine that everyone needs to be in touch with their own conscience.
The motion had alleged 5 cases of misconduct against the Chief Justice, including an allegation he allegedly abused his authority to arbitrarily assign cases of particular advocates in politically sensitive cases to select judges in order to achieve a predetermined outcome.
Now, the next stage is also fraught with delicate challenges. The MPs will now approach the Supreme Court for an appeal, but in accordance with the principles of natural justice, neither the Chief Justice of India nor the other remaining 4 senior-most judges, whose names also appear in the impeachment motion, may be able to hear the matter.
The 4 justices had spoken out, demanding the Chief Justice implement changes. So who will hear the challenge?
We are confident that when we move that petition, the Chief Justice has nothing to do with it.
It can't be rejected by the registry. So whatever you file has to come before some court. Maybe right, maybe wrong. So in the facts of this case, according to me, it should go to judge number 6.
However, the widely respected jurist Fali Nariman argues for the impeachment process to be dropped.
All these charges are just, to my mind, very puerile. Here's the man who is demitting office in any case in October, when there's just a few months left. Why have you brought it? I can understand if he had 5 years left or 4 years left of his term of office, and then you can argue till the cows come home. But not now. I'm sorry, that doesn't make any sense. It only demeans the institution which he is heading.
With Sunil Prabhu and Sonal Mehrotra Kapoor in New Delhi, Soumya Menon, NDTV.
Well, it could have been quite an unusual day at the workplace in the Supreme Court today. In the morning, like we said, the news came of the Vice President rejecting the impeachment motion against the Chief Justice. Soon after, there was the regular morning tea of the Supreme Court judges, though it ran longer than it normally does, which is 10 minutes. So that's why court today started at 10:42 instead of 10:30. But apart from Congress leader and senior lawyer Kapil Sibal's declaration that it's against his principles to appear before the Chief Justice, it was business as usual at the Supreme Court. The Chief Justice sat through all his cases and so did all the other judges. Of course, the next interesting turn will be when the opposition parties go to the Supreme Court against the Vice President's decision. We'll have to see which bench that ultimately goes to and who will decide that bench. Joining us on the program this evening, senior advocate Prashant Bhushan is with us. Also Dr. Subhash Kashyap, who's a constitutional expert and a former Secretary General of the Lok Sabha. Mr. N. Ram, senior journalist and chairman of the Hindu Publishing Group. Here in the studio with me, Mr. Pawan Khera of the Congress, and Raghav Avasthi, who's also a lawyer and member of the RSS. Let me take this question to you first, Mr. Ram. As an editor, how are you viewing these developments that have taken place in the last few days and sort of the rejection of this impeachment motion by the Vice President today? Do you think that this settles the matter?
I think the Vice President has acted arbitrarily, and his summary rejection in great haste is completely out of line with what the Constitution lays down, as far as I can understand. I mean, you can't prove it at the outset, at the threshold. Proven misbehavior can't be demonstrated at the threshold. It has to be gone through, and you talk about judicial responsibility. There's a whole campaign for it, and if this is the only way, I mean, I'm talking hypothetically. Let's remove the persons out of the equation right now. How do you hold a judge accountable for such alleged acts? And if this is reduced to a nullity, as the present action seems to suggest, then there can be no place in India for judicial responsibility. That's the heart of the issue. And Prashant Bhushan, for decades now, has been campaigning on this issue, and many others as well. So I think the Vice President, I regret to say, is completely out of line on this.
Well, strong words there from you, Mr. Ram. Dr. Subhash Kashyap, I know you had a very different view on this, and that you believe that actually what the Vice President has done is the right thing. How do you respond to Mr. Ram's very strong observations, though, that this was out of line and arbitrary? And I think the point he makes is, at the end of the day, the Constitution does provide for impeachment motions to be tabled and to be taken up, and ultimately they have to be decided on merit by a committee that is supposed to be set up to look at them. How do you see this, sir?
Well, number one, those who talk of the impeachment motion perhaps have not seen the Constitution, because there is no provision in the Constitution for impeachment of a judge. Impeachment procedure is only for the President of India. Article 124, which provides for removal of the judge, is entirely in different language. It requires a different majority for passing a motion under 124. The results of voting are different, the majorities provided are different, the language needed is different. So first we should disabuse ourselves of the impression that there is a provision for impeachment of a judge anywhere in the Constitution. And it is not merely semantic or technical difference, it is very substantial. Second, the notice that was given, it is quite clear from the law and the rules that the chairman of Rajya Sabha can either admit the notice or reject it. The word used is or reject it. So the chairman has acted within his jurisdictional limits to reject the motion, and he rejected it because no prima facie case was made in the motion. It has to be on the basis of substantial charges, but those who gave notice perhaps were not themselves convinced of any substantial proof in favor of the charges they were making. It is obvious from the language that they used. In one of the 5 charges, they speak of appears to be. In the second charge, they say it may be. In the third one, they say it is likely. So they are obviously not convinced of their own position.
Well, that's an important point you make, sir. I want to
those
take
who gave notice of the.
Sorry, sir. I just want to interrupt you there because you made a very important point about the way the language was drafted in the charges that the opposition made. I'll take that to Prashant Bhushan. Mr. Bhushan, how do you respond to Mr. Kashyap there? Also on the point that he's making, and if you could clarify this for us, because from what we understand, the only way to remove judges is through a process of impeachment. So, what is Mr. Kashyap saying here?
No, about impeachment and removal, he is just making the wording of the Article 124 is removal of a judge. Substantially, you see, one has to understand what is the procedure prescribed for removal of a judge. The procedure is first 50 MPs of the Rajya Sabha or 100 MPs of the Lok Sabha sign a motion for removal of a judge and submit it to the chairman of the Rajya Sabha or speaker of the Lok Sabha. Thereafter, he has to examine the motion. He can certainly reject it, but if he admits it, he has to constitute an inquiry committee of 3 judges, 1 sitting judge of the Supreme Court, 1 sitting Chief Justice of a High Court and 1 jurist. They then examine the charges and virtually hold a trial of the judge. And if they come to the conclusion that the charges are proved and that it is a case of proved misbehavior, then only the matter goes for voting in the 2 houses of parliament. Now in this light, the role of the speaker or the vice president is only 2 things. He can reject it on only 2 grounds. One is if the motion does not have the requisite number of signatures of MPs, and second, if the charges on the face of it are not charges of misbehavior. It is not even required in a motion for removal to give any material in support of the charges. You just have to make those charges. It is the prima facie case is to be decided by the MPs who are signing that motion. They have to see whether, according to them, they have a prima facie case to move a motion for removal. Thereafter, it is not the job of the Vice President or the Speaker to examine and reject the motion on the ground that these charges are not substantiated. The substantiation comes during the inquiry proceedings. There various evidence is produced, further evidence can be called for. In this case, there were very, very serious charges of bribery. Now Mr. Kashyap says that the motion says that it appears that he has been party to this bribe, or that he has agreed to accept this bribe. It is true, it says that, but this will be proved during the inquiry, because the CBI had collected a lot of evidence. A lot of things have been mentioned in the motion or in the supporting documents,
Bhushan, that
which
you
seem
agree,
to suggest that he has.
So are you saying, as Kapil Sibal also said earlier
Yes.
today, that you feel that what the Vice President did was, he used the word illegal and unprecedented. That's what you think it is?
They're totally illegal, totally illegal. You see, he has no business to go into the merits of the charges. That is not his job or jurisdiction. That's the job and jurisdiction of the inquiry committee that has to be appointed of 3 judges. He can't go into this question, therefore it is totally out of line.
Okay, so Raghav,
and that is why it is unprecedented.
Okay, Raghav.
I think Nidhi, Mr. Bhushan, unfortunately, he seems to not have read Section 3, Clause 1 of the Judges Inquiry Act, or I think the other possibility is that he is being deliberately disingenuous. Because once notice is given of motion, the Speaker and the case may be the Chairman, he may, after consulting such persons, if any, as he thinks fit, and after considering such materials as may be available to him. So the Speaker, it's not as if the Speaker is the Chairman is some sort of a postman. He has to consider the material, he also has to consult persons, and then he has the discretion to either admit the motion or refuse to admit the same. Now, although there is not much judicial precedent in this regard, instinctively my sense is that this exercise of discretion by the chairman in this case, or the speaker if the motion were moved in the Lok Sabha, is justiciable only to a very limited degree. The Wensbury principles, as Mr. Bhushan is doubtless aware of, that is illegality, procedural impropriety and irrationality, are much wider. However, in this case, it is very limited. Even the Supreme Court can scrutinize this decision only to an extremely limited extent, and this is something that somehow Mr. Bhushan does not seem to appreciate. And the text of the section is explicit. It says that the material has to be perused by the chairman.
Raghav, do you think?
And just one more point. And this is a point that was made by Mr. Kashyap also. If you look at all the charges, I have all 5 of them here. Now it says that in relation to Prasad Educational Trust, even according to them, there is only prima facie evidence. While Article 124(4) talks about Article 124(4) says that only when there is proven misbehavior or incapacity, which basically means that misbehavior or incapacity have to be proved before such a motion for impeachment is initiated.
I get your point, but let me ask you this. Do you think the Vice President could have maybe held more extensive consultations on this, maybe for a few more days, because it was very quickly dismissed?
No, I will tell you why it was dismissed. Because there is a concept, there is a concept under law, and it is known to the CPC also. It's known as Order 7 Rule 11, which basically says that if your plaint or the material in the case or on record as the case is here, taken on the face of it, seems to be barred under any law, or it does not disclose any serious charges, then it has to be rejected summarily.
Let me take this to Pawan Khera. Pawan, I think one of the biggest criticisms of the opposition has actually come from someone as eminent as Fali Nariman. This is not a politician, you can't say it's the BJP, etc. An eminent jurist like him says that this was not right. He says it's a black day for the Supreme Court, that this will shake people's faith in the institution of the judiciary. How does the Congress see Fali Nariman's criticism first?
Absolute respect, heartfelt respect for Mr. Fali Nariman. I think the darkest day for the Supreme Court in this country was in January, when these 4 judges came out and said, unless this institution is preserved, I am quoting them, democracy will not survive. Now tell me, January, Feb, March and April, what happens? There is no full court meeting. Why not? May I please? There is no full court meeting, Nidhi. Yes, it's an internal matter. Yes, the internal matter was made public by none other than 4 senior judges of the Supreme Court. And once it becomes public, whose responsibility it is to take their warning seriously that democracy will not survive, and yet give them 3 months for the full court to meet and sort out these issues of fixing benches, arbitrarily allocating cases to benches. All these are very serious charges. It's not Judge Loya, it's not X, Y or Z case, no, not at all. We had sought the appointment from Honorable Vice President 1 week before Judge Loya's matter. He was travelling to the northeast. He gave us the appointment a day after Judge Loya's judgment came. Now, what is wrong with the Congress if it does not take up these issues? I think that's when we'll all be disappointed with the Congress party, with the opposition. If you don't take these warning signs in time, there is a precedent. In 1970, Justice Shah, there was an impeachment motion against him in the Lok Sabha. Mr. G.S. Dhillon was the speaker. He consulted the Chief Justice of India, I think it was Mr. Hidayatullah, Justice Hidayatullah, and took some time. The charges were not even there, yet he took time, he consulted the CJI and then dismissed the petition.
So,
let me ask one point, 10 seconds. I think as far as the press conference of the 4 judges is concerned, the matter has been settled. Now there is a subject-wise roster in place. There is a subject-wise roster in place which is unprecedented in the history of the Supreme Court, and like in all chartered high courts, the Chief Justice have kept all PIL matters for himself.
Critical cases, which I am talking about, are still where they should not be.
But this is a subject-wise roster, sir. Subject-wise roster there is in the Supreme Court.
Let me ask you.
The Chief Justice has no discretion in this regard. This is deliberate. This is deliberate.
Okay, one second.
No, this is deliberately disingenuous.
What you are saying is also deliberate.
No, 1 second. Gentlemen. Pawan, I want to ask you. If the Congress is so convinced, and I've asked Kapil Sibal about that as well, and we're going to play out that interview shortly, that the Congress is so convinced that what it is doing is right. Your own former law ministers have been critical of this move. Ashwani Kumar, Salman Khurshid, Dr. Manmohan Singh's signature is not on this, and Fali Nariman points that out. I mean, I know the Congress says that Dr. Manmohan Singh, we didn't ask him because he's the former Prime Minister, etc. But if it's something that's so important and it's about, upholding institutions, I'm sure he would have put his name to it.
There is a stage in time for everything. Now, as far as Dr. Manmohan Singh is concerned, Mr. Sibal very clearly said that out of respect for the office of the former Prime Minister, it's an institution. And we do know how to respect institutions, unlike my friends on the other side. Coming to the former law ministers, look, my friend Raghav Avasthi will keep saying there is no democracy in your party, or this, that and other. This is a clear example of how democratic can our party get, that they are openly voicing their differences about this in opinion. Nothing wrong in that. We don't have a Hitler Shahi somewhere, ye karna hai to yahi karna hai. This demolishes all their claims for the last several decades that they keep trying to peddle. So this demolishes it clearly. So we are absolutely a free party. If somebody feels that this should not have been done, fine. Why not? Respect for them also. But in the collective wisdom of a lot of opposition parties, what we thought was right, we are doing.